Hello everyone and welcome to today's Mondac webinar in association with Knights, who will be providing in-depth insights into the most pressing employment law developments in the UK and their impact on employers in 2025. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Justin Gauvier's extensive legal expertise and a commercial approach has seen him trusted by some of the region's largest corporates and SMEs for business critical advice. He provides strategic guidance to boards, advising them prior to drafting business and workforce plans. Justin works closely with UK and US General Counsel and HR directors, supporting UK subsidiaries with the implementation of global strategic initiatives. Justin helps clients defend complex employment tribunal claims and has particular experience in defending whistleblowing, discrimination and 2P claims, as well as disputes involving breaches of restrictive covenants and confidential information. Nicola Adwyer is a seasoned employment law expert with more than 20 years experience advising HR leaders and businesses on a wide range of workplace challenges. A specialist in navigating the complexities of UK employment law, Nicola supports national and multinational clients with issues such as drafting employment contracts, managing grievance and disciplinary processes, handling redundancies and defending employment tribunal claims. She is also a trusted advisor on employment aspects of corporate transactions, including 2P, ensuring seamless transitions during business changes. Before I hand over to Justin and Nicola to begin today's webinar, a quick housekeeping item. You are able to submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. We'll endeavour to answer as many questions as possible during today's webinar and during our Q&A session, but only those that directly relate to UK law. Any other questions will be sent to them after the webinar. It's now my pleasure to hand you over to Justin and Nicola to begin. Thank you.
Thank you very much, Dan. So obviously, as Dan said, we're going to be talking about employment law and the key developments for 2025. Have the next slide, please. So today we're going to be talking about sexual harassment and the new legislation, employment rights bill, the update on legislation and guidance. We'll also be looking at recent case law, and then again, as Dan said, we will be having the Q&A session at the end, so if you want to pop your questions into the chat box. Right, if we could go to the next slide. So let's start with sexual harassment then. So in response to the Me Too movement, which I think everybody would be aware of, the government consulted on whether the rules for sexual harassment were actually working effectively. The result of that consultation was that new preventative measures should be introduced, and these duties came into force on the 26th of October 2024. So the new regulations actually impose a duty on employers and companies to take reasonable steps to prevent sexual harassment of their employees. So slightly unhelpfully, we don't actually have what those reasonable steps are within the legislation, and it seems to depend on the size and nature of the business and what would be considered reasonable for them. However, it's important to actually note that you should deal with any potential risks of sexual harassment before one actually occurs within your business. So if we take it back to the beginning and look at what would actually constitute sexual harassment, if I could have the next slide, please. So as per the slide, sexual harassment occurs when an individual engages in unwanted conduct of a sexual nature, which includes unwelcome or uninvited conduct, which then creates an intimidating, hostile, degrading, humiliating or offensive environment, or then actually violates the employee's dignity. So if I could have the next slide. This obviously includes things such as sexual comments, gestures, touching, hugging, and anything of a physical nature. And also, what many people may not realise is that it only actually takes one incident to actually constitute an act of harassment. So if I could have the next slide. So as I sort of said already, employers are under a duty to take reasonable steps to prevent sexual harassment of their employees. So we're just going to look at how that can be regulated. So as part of the new regulations, the government provided the Equality and Human Rights Commission with the power to take enforcement action against companies where they have failed to take the reasonable steps to prevent sexual harassment. So the EHRC can go ahead and undertake an audit within the company, go in and investigate, and subsequently implement penalties if they feel that that would be appropriate. So what the EHRC has done is they have provided guidance as to what should be done to take reasonable steps to prevent sexual harassment. Obviously, these are not binding, they're not in legislation, but these factors will be taken into consideration by an employment tribunal when determining whether or not an employer has taken reasonable steps to prevent sexual harassment. So just looking at the potential things that you can do then. So the first one is introduce a standalone sexual harassment policy. So I know a number of employers already would have anti-bullying and harassment policies, but it's actually necessary to actually have a standalone one and not simply just put in a paragraph into your current anti-harassment policy. Also, when you actually introduce it into the handbook, you shouldn't just quietly put it into the handbook and leave it there. It's the case of actually informing employees that you have introduced and implemented a sexual harassment policy, and therefore you would want to ideally get the employees confirmation that they have received and read it. Again, as I said, you don't want to just sort of send it to them. If you can provide training to employees on the sexual harassment policy as well, then that would help prevent any risk of any claim. Also, you're required to undertake risk assessments and identify whether there are any concerns which may lead to sexual harassment. So the types of risks that really you should be looking at include maybe out of hours working, events maybe where there's alcohol, which is always seems to be a trigger for sexual harassment claims, in particular when it comes to Christmas parties. You're also looking at elements of lone working, potential social media contact between employees, even if outside of work hours, and also looking at whether or not a potential culture of banter exists within the company, and looking at how that could maybe be restricted so as to avoid any sort of sexual harassment issues. So undertaking the risk assessment is obviously extremely important, as it appears from the guidance that an employer is unlikely to be able to comply with the duty of taking reasonable steps to prevent sexual harassment if they have not actually identified what those potential risks may be. So I also have an open door policy, which in effect means that You can engage your staff by having one-to-ones with them, and then encouraging anybody to come and talk to you if they were concerned about any act of sexual harassment, whether that be directly to themselves or whether they have seen something which is happening to one of their colleagues. You may also want to have things like exit interviews, which will provide an opportunity again to ask employees whether there's been any concerns. So you also need to make sure that you have effective processes in place for complaints of sexual harassment. So you would need to be looking at which managers you would be asking to deal with any complaints of sexual harassment, and really importantly to provide them with the training for them to be able to deal effectively with any complaints that they may well receive, because you're likely to find that the managers without the training may find it difficult to know what to say or what to do. As I said, mandatory training not only for managers but also for employees as well. And then what you may want to do as a company is to regularly reflect on any complaints of sexual harassment, evaluate the steps that you've taken, and review how you can improve those processes and procedure. And then also the guidance addresses third-party harassment, and so that should be identified in the policy as well. And again, you should highlight that any third-party sexual harassment will not be tolerated. Again, encouraging workers to report it to the company and not feel fearful about it, because they may well be making these allegations about customers, suppliers, but really sort of showing that you would take any concerns seriously. Also, what steps you will take to prevent any sort of third-party harassment. So this could be notices saying you have a zero tolerance approach to sexual harassment, addressing it in any letters of engagement, and sometimes having a recorded message on any phone line. And again, identify what steps you will take to remedy a complaint or prevent it from happening again. That may well be things such as banning a customer, reporting any criminal acts to the police, or informing obviously their employer. So if an employee actually wishes to proceed with a claim of sexual harassment against the company at the Employment Tribunal, any compensation that could be awarded is uncapped. And furthermore, the tribunal actually has the ability to award an additional uplift of 25% if they do not believe that you've taken reasonable steps to prevent sexual harassment. Hence the reason it's really important to go through those points that the EHRC has provided. But also, not only is there the risk of expensive litigation if there's been acts of sexual harassment, but also damage to the company's reputation. If a claim is made at the Employment Tribunal, it is public. It could also affect recruitment and employment, employee retention, as obviously people don't necessarily want to work at a place where there has been known acts of sexual harassment. Also, there's the potential breach of the mutual trust and confidence, which could lead to an employee resigning and claiming constructive dismissal. So next slide, please. So although these regulations only came into force in October 2024, there are already changes proposed by the government. So at the moment, as I said, that an employer is required to take reasonable steps in regards to sexual harassment, but it's proposed to be changed to all reasonable steps. Now, I know that may well feel that it's a bit of a minor change, but it is likely to make it even more difficult to defend the failure to do something which would have prevented an act of sexual harassment. However, hopefully and helpfully, it's indicated that the exact requirements for reasonable steps may well be identified, which, as I said, will be helpful if it does. And then just in regards to the third party harassment, at the moment, there's not an ability to bring a freestanding claim against a company for third party harassment, but the proposals are that it will be extended so that an employee could bring a claim against the company for failure to deal with harassment by a third party. Right, I will now hand over to Justin to address the other proposals included within the Employment Rights Bill.
Thank you, Nicola. Yes, so this started last summer when in the late spring when the Labour Party put employment law reform front and centre in their election campaign, and it was actually, I say as an employment lawyer, quite refreshing to see it taking centre stage. This was taken from their manifesto. The Labour Party clearly felt that Britain's employment laws were outdated and not fit for the modern economy, and by that I think they were talking about the gig economy that we have seen a great rise in. In truth, I think that is possibly more a political statement than an economic one. I think it depends from which viewpoint one is coming, because obviously increased flexibility had come in over the previous 14 years, and some would argue that that was at the expense of workers' protections and workers' rights. And there's often that friction between flexibility and workers' rights. And so, as I say, I think that comment was probably at least as much political as it was economic. And certainly the Labour Party believed there had been an erosion of workers' rights over the previous 14 years, and they were going to do something about it. And of course, we all know what happened in the election. And next slide, please. Therefore, the Employment Rights Bill was hurriedly drafted in the first 100 days. You may recall there was a big push in the first 100 days, which they had promised to come up with various pieces of legislation, and the Employment Rights Bill was one of them. And I think because it was done very quickly, there were a number of questions remaining in the draft, and those are currently being worked through and will continue to be worked through over the next year or two. So what I'm going to talk about generally is not law now, but will be law in some shape or form, and I'm going to talk through the main parts, pillars of the Employment Rights Bill, but I'm particularly going to focus on what I think employers should be doing now to prepare themselves for the changes, and a lot of it actually is good practice anyway and probably should be being done anyway. So we start with unfair dismissal. Now, this is quite an interesting one, and it's probably the thing that has caught the eye the most and been talked about the most. The bill states that there will be day one rights for an employee to bring unfair dismissal. And just a bit of background, generally speaking, for most normal unfair dismissal claims, an employee has to have been employed for 2 years, a qualifying period of 2 years at the moment, to be able to bring a claim for unfair dismissal. There are a number of areas where we have automatic unfair dismissals that don't need that 2-year qualifying period, but most do. And I remember, because I've been around for a while, this qualifying period has gone up and down over the years. The new government clearly felt 2 years was too long. And you know what? I am clearly an employer-biased employment lawyer, but 2 years is quite a long time, and I think less scrupulous employers treat that as just a 2-year probation period. So yeah, I can see I can see the issue with the length of the qualifying period. So what the bill says is that it will be a day one right. So any employee will be able to bring a claim for unfair dismissal from the moment they start, not before though, but for the moment they start. But the compromise, if you will, is that there will be this statutory probation period. It's called an initial period of employment. We think it's going to be 9 months. I'm pretty sure it's going to be 9 months. And during that period, the employee will be able to dismiss, the employer will be able to dismiss an employee, but they will have to go through a process. At the moment, there is no unfair dismissal. There's no process that needs to be gone through. So there'll be a light touch process. We don't know the full details at the moment, but it will include a meeting. Pretty sure that meeting, the employee will have the right to be, well, I'm sure they will, to be accompanied by a trade union representative or workplace colleague, like any normal formal meeting. As long as the employer goes through that process, they will be able to dismiss fairly. And if an employee brings a claim because they were dismissed during that period, then there will be a reduced cap. As I'm sure you're all aware, there's a compensatory cap in the amount that an employee can be awarded for an unfair dismissal claim. And it will be lower if the dismissal is during that initial period. But the key here is the employer will still need a reason to dismiss. They can't just do it for no reason and send them a letter. There will need to be a process, and it's looking like redundancy will be a straightforward day one right. So the employee will not be able to dismiss by reason of redundancy in that earlier period. They will have to go through the normal processes that they would have to anyway to defeat an unfair dismissal claim. So this is a pretty seismic change, but it's not going to happen yet. It's going to happen not before autumn of 2026. What we don't quite know yet is what transition arrangements will be in place before then, by which I mean, if it happens on the 1st of October 2026, will it only affect employees employed after that date? What about those who've been employed during the last 9 months? How will that all work? But in broad terms, it's not going to come into force for 18 months. So what should you be doing now on the next slide, please? Well, as I say, really just a lot of things that employers probably should be doing anyway. The recruitment process is going to become critical because you as an employer are not going to be able to treat the first 2 years as a one big long probation period. You've got to make sure as best you can that you get the right person for the job first time, because you will have to go through a process in order to dismiss that person if they do not come up to scratch, if they aren't just not good enough for whatever reason. So I think recruitment processes are going to become much more rigorous. I think they are going to involve probably more tests. And I know that recruitment processes are a bit of a minefield anyway around discrimination, but we can work our way through that. But they're going to have to become more rigorous. I don't know what's going to happen about references. As you know, I'm sure, because you've probably seen it, most references these days just say Joe Bloggs worked from X date to Y date as a financial assistant, and then a big couple of paragraphs about how there's no responsibility on the part of the employer and all the rest of it. I'm sorry, because that practice has been driven by the lawyers, I'm afraid, but it's really unhelpful if you're trying to get the right person for the job, that you are pretty blind as to their employment history from a previous employer. So I think something might have to give on that. I have to say I'm increasingly coming across employers who just don't bother with references anymore. And the first time I heard it, I was pretty gobsmacked, but you can sort of see why. Probation processes are going to have to be really, they'll be statutory prescribed anyway. There'll be a kind of a process will be set out in a framework, but employers are really going to have to deal with probation processes in a way that they just don't at the moment. Proper measure against targets, objective measurement, make sure that the employee is able to do the job. And look at reasons why they can't, if they can't. But meetings, regular updates, touch points, that's all going to have to happen, because I suspect it's not going to be good enough at the end of the 9 months just to say, actually, you weren't good enough, let's have a meeting, and then off they go. They're dismissed. I don't think it's going to work that way. So I think that's an important point, and check your probation processes right now. Make sure they are what's required, and then when I'm sure there'll be a new probation period prescribed by the government, and you can check against it and make sure. But start using it. Get the managers into the habit of using these probation periods. There is some positive news here for employers. I think what we see now is a lot of mislabeling of claims, by which I mean someone's dismissed in the first couple of years of their employment, they can't bring an unfair dismissal claim, so they put in a discrimination claim or a whistleblowing claim or something that it probably isn't, and they themselves probably don't think it is. It's just very unfair. And now, going forward, they will be able to call it what it is, which is an unfair dismissal, and we won't get sort of sidetracked with all these other things around discrimination and the like that perhaps are not such strong claims. Employees going on sick leave is a little bit of an issue if an employer is trying to go through a performance process, and that's now as well as in the future. And we are increasingly seeing employees going off sick during a performance process, and it makes it very difficult. It's very difficult to measure performance when the employee isn't there. But the difference here is that when you get to the end of the 9 months, you kind of have to make a decision, because that's the end of the period where you can use the lighter touch. So I think it's going to be quite tricky if the employee hasn't been at work for a few months. I'm afraid I don't have the answer to that one at the moment, but the one thing I will say is that employees on sick leave is much easier to deal with if you have a really good occupational health company on board who can give real guidance to you and the employee, to everyone, about what the problems are and how they can be overcome. Redundancies I've already talked about. The one thing I would urge is for anyone in HR to get involved in the consultation. It's going on now. It'll be going on for months and months. There are obviously lots of voices, particularly on the employee side, the trade unions, etc. Feed into the consultation. You can go online onto the Gov website and get it all. And if you've got views on it, make your voice known. And we will see what happens next autumn. But it is going to be a slightly different world. Right, yeah, no, that's fine. Next slide, please. We now move on to what's called fire and rehire. And I put there that this is a bit of a wolf in sheep's clothing. I think it didn't get much publicity when it was first mentioned, but it is now. And the reason it is now is because basically the bill says that it will be automatically unfair. Do you remember a moment ago I said there are some circumstances where a dismissal is automatically unfair, come what may? And it will be automatically unfair if an employer dismisses an employee because the employee did not agree to an employer's attempt to vary their terms and conditions of employment. So employer says to the employee, I want you to work 8 till 5 instead of 9 till 6. Employee says no, employer sacks them. Automatic unfair dismissal. The only way that an employer will get round that, well, not get round it, but have a defence to it, is if the business is in financial difficulties such that it's affecting the very ability to carry on the business. And even then, there'll be a new code which will make it, there's already a code in place as we speak, which will make it very difficult for employers to effect a dismissal based on an employee not agreeing to new terms and conditions. So next slide, please. It applies to any contractual terms. It clearly gives more leverage to employees, because very often at the moment an employer will try and get through a change by accompanying it with a pay rise, but that's not going to be possible going forward. Or, well, it's possible because the employee can agree to it, but it's likely the employee will ask for an awful lot more money to effect that change. And I have a genuine concern about this, that it could lead to more redundancies, because you will recall that during the pandemic particularly, there was a strong emphasis on looking at all alternatives before you make any redundancies. And the alternatives were things like job sharing, reducing pay, reducing hours, all these things that necessitated a change in terms and conditions. And if the employee doesn't agree, it's going to be very difficult to do any. It was going to be impossible, pretty much, to do any of that unless the business is literally going under. And so those options might be out the window, which means that the employers are going to go more quickly towards redundancy, which is a concern. I think it's a real concern. The other issue we don't quite yet know is whether the business. It's about whether the business has the ability to continue, whether that's that part of the business, whether it's a department. What about a subsidiary which is doing really badly and is about to go under, but actually the global corporate above it is very healthy? How will that work? And we just don't know. So, what should you be doing at the moment? Auditing everything, all your paperwork. So the contracts, the handbooks, making sure that what's in the contract should be in the contracts and not in the handbook, because it's easier to change things in the handbook generally than the contract. So make sure you've got the right things in the right places. Look at flexibility in your contracts. I'm sure you've all seen the clause that says the employer reserves the right to vary any of these terms and conditions on 28 days notice. Just to be clear, that doesn't mean you can, but it gives, because there is an overriding need to be fair. But it does give some flexibility, and also make sure there's flexibility within the clauses themselves. So, for example, maybe a flexible start and end time, so that it's not a contractual change if you want them to start or end at a different time. You look at those sorts of things. Try and future-proof your contracts. And I think most of all, make sure that the contracts actually reflect the conditions that are currently being worked under. The number of times I go out to an employer and I say, well, that's a bit of a strange clause. And they say, oh, no, that's not right. We did that years ago. We've just never changed it. That's the line. Well, now change it, because you may not be able to in a year or two's time. So go through that, get everything up to date is my best advice. It does appear a bit of an uncompromising reaction to some high-profile incidents. I don't want to be sued for defamation, but I think we've all read the papers about particularly a shipping company that didn't do this in the best way possible, and it was very high-profile, which led to this. And actually, moving on to the next slide, I think we've got the same issue with zero-hours contracts. When I first started working as an employment lawyer, zero-hours contracts were actually a very useful tool for flexible working that suited both the employee and the employer. Without stereotyping, often retirees or students or working parents who didn't want to come back full time and wanted to be able to say no if they didn't want to work in a particular week. But of course, what happened was, and again, I don't want to be say anything defamatory, but there are a number of high street businesses that actually decided their whole workforce would be on a zero-hours contract, which was never really what was meant. So because of that, it got a bad press. I feel a bit sorry for zero-hours contracts, really, because they did get a really bad press, but it was more about the way they were being used. So the government were very clear they were going to ban exploitative zero-hours contracts. There is no ban in the Employment Rights Bill, but what there is the obligation on an employer to offer guaranteed hours based on an average working pattern over 12 weeks. It's not quite, this is really complicated legislation and is going to be an administrative nightmare to comply with and to deal with. But basically, if after 3 months, more or less, the employer's been working a consistent pattern, if they are on a 0 or low hours contract, they should be offered that pattern, whether it be 10, 20, 30 hours a week. We don't know how detailed it will be as to whether it needs to be particular times or days, but they will receive an offer which they can reject to work set hours. One of my main concerns with this was seasonal workers. If you're in the tourist industry, for example, you have lots of work in the summer and frankly no work in the winter. So the government is allowing an exception for limited term contracts, what we call now fixed term contracts. So I think employers will be putting those workers onto fixed term contracts rather than enduring 0 hours contracts. It's going to apply to agency workers as well. So that's going to reduce flexibility. And then separately, I'm not going to go into detail now, when an employer starts changing shifts, there is an obligation to provide notice and pay compensation. You can't just change shift times 2 hours before. Okay, next slide, please. So the questions: what is a low hour contract? Is it 1, 2, 3, 4, 5 hours a week? Avoidance measures. Well, I can see lots of employers just having contracts at the absolute bare minimum, 5 hours a week or whatever, to try and avoid these rules. I can also see some unintended consequences. I can see there being less work out there generally because employers will just make do with what they've got rather than having people on 0 hours contracts that they bring in and when they need them and then they don't when they don't need them. But it actually provides more work overall for more people. So I can see that potentially being a bit of an issue. There are links with what the government's trying to do about worker status and day one rights as well. I think the flexibility is definitely being lost, but there is more worker protection. So as I said about 10 minutes ago, it will depend what your political view is as much as anything as to whether you feel the balance is right. An employer now should be looking at all their atypical workforce. Look at who they've got on the books, what levels of work they have and they need, and just be ready for this. Just be ready to be able to operate in the new world. Look at what the solution is going to be for you, given the work patterns and the work volumes you have. And I've already said it's going to be an administrative nightmare. I'm quite grateful I'm not in payroll when this all comes out. Okay, next slide, please. I'm going to skip very quickly through the next few. Employment tribunal limitations are going up broadly from 3 to 6 months. And with ACAS conciliation on top, it means that an employer might not have a claim against them for possibly even 9 months down the line, certainly 7 or 8 months down the line. I don't know whether this alone will lead to more claims or fewer claims, because on the one hand, they've got longer to bring a claim, so you'd think there's going to be more claims, but it's a longer time for the parties to settle the claim, and more importantly, it's a longer time for the employee to get another job. And you won't find this in any law books, but generally speaking, if an employee gets another job, they become less concerned about bringing a claim for the dismissal or whatever it is from their previous job. So this alone might not bring about more claims. However, all the other things that the government is doing probably will lead to more claims, and so I am very worried about whether ACAS and the employment tribunals have enough resource to handle all of this. But that's one for another day. Next slide, please. So there are lots of other changes that I'm not going into detail about today. Family friendly, a lot of trade union stuff. That the trade union topic will be a whole seminar in itself. But have a look. If you've got any questions, you know where we are. Drop us a line. We can talk to you about that. Next slide, please. I just wanted to very briefly talk about what is not in the bill, and we thought would be. The right to switch off. Everyone thought that was going to be in there. It's not. There might be a code of practice about it, but it's not going to be enshrined in legislation. A ban on dual discrimination. So dual discrimination, when people aren't sure whether it's because of one protected characteristic or another, so they think, well, maybe it's the combination of both, and it's fair. It's a fair comment. We thought that might be included. But it's not. The simplification of the worker status, because as you probably know, there's a 3-tier system in the UK. We've got employees, we've got workers, and we've got the genuine self-employed. I think the government thought that was just a bit too much to deal with at the moment. I think they will, but not yet. And then pay gap reporting, we've got it for gender. I think it will come in for ethnicity and disability probably quicker, funnily enough, probably quicker than some of the other stuff I've talked about, but that's not in the Employment Rights Bill. So next slide, please, and over to Nicola.
Thanks, Justin. So apart from the proposed legislation and the new sexual harassment legislation, what else have we got? So we've got the Neonatal Care Leave and Pay Act, which came into force on the 6th of April of this year. And this is expected to assist around 60,000 new parents. So the neonatal care actually allows parents to, or gives them the right to have leave once their child has been in neonatal care for at least 7 days. So neonatal care may be because there's been an issue during the pregnancy and the birth. The child could be ill or injured or maybe born early, and so they've had to go into neonatal care. But the child does not actually need to be admitted to neonatal care as soon as they are born to actually get the right to take the leave. It can happen anytime up until they are 28 days old. So they need to be in neonatal care for at least 7 consecutive days for parents to actually be entitled to the right to take the neonatal leave. So parents have the opportunity to take anywhere between 1 to 12 weeks of neonatal care leave, and they would be entitled to statutory neonatal care leave pay, which currently mirrors that of maternity pay, which is £187.18 per week. And the thing is with the neonatal care leave is that it can actually be added to the original period of leave. So if, for example, you have a parent that is taking paternity leave for 2 weeks, they would take their 2 weeks paternity leave and then add on the neonatal care leave at the end, which could potentially, say, be for another 2 weeks. The same applies with maternity or adoption leave, is that it would be added to the end, providing that the actual neonatal care leave is taken within 68 weeks from the date of the birth. As with all of these sort of family-friendly policies, employees must not be subjected to any detriment because they've taken the neonatal care leave, or must not be dismissed because of it. And this applies to both parents of the child. So it's really recommended as well, with all the other family-friendly policies that you would have within your staff handbook, is that you go on to again implement a further policy, being that of neonatal care leave, so that both the employers and the employees know where they stand and what they would be entitled to. Just to say that the neonatal care leave is a day one right. So that's the legislation, but what about any guidance that has been provided? And so ACAS this year has published guidance on neurodiversity at work. I mean, obviously this has been becoming an increasing talked about topic over the last few years. And so ACAS in their guidance have just published ways that employers can support employees who are suffering from any conditions such as ADHD, dyslexia, autism. I mean, the list goes on. I'm not going to list them all here, but it's just really how employers can help support those employees. And obviously the whole thing is that each employee will deal with it differently. So there's no sort of overall response that you could give to everybody, and that it's the case of treating everybody differently and providing them with the support that they may need. Otherwise, there is a risk that they will be able to claim that it's a disability, and they would subsequently be able to go on and claim disability discrimination. And finally, we've got the statutory code of practice on dismissal and re-engagement. So that recommends a procedure that employers should follow when it comes to dismissing and re-engagement. I mean, obviously, as Justin has already discussed, the fire and rehire may well change as from the date that the Employment Rights Bill becomes legislation. However, at this time, it's still recommended that code of practice is followed. Otherwise, there is a potential uplift, again, of 25% if any employee brings a claim at the Employment Tribunal. Okay, if we can have next slide. So increases, there's a lot of talk, or there has been a lot of talk about this and how employers are getting increasing costs and potentially struggling with those. So obviously the national insurance contributions from an employer was increased as of the 6th of April from 13.8% to 15%. And then the threshold was reduced, which effectively means that there'll be a higher cost for employees. And they're saying that the actual average cost has been estimated for each employee of £800. That's just on an average on an annual basis, which an employer will have to find. So not only have we got those, but we've also got the increase in the national minimum wage and also the national living wage, which is all causing higher payroll costs for businesses. Next slide. So what does all this mean? Will businesses be able to survive? I suspect that it's the smaller businesses which are going to find it's more difficult, but even the bigger businesses may find that their expenses are sort of the costs are being pinched and that they need to look at how they can budget better. And will this then have an effect on the actual employees? Will we be looking at freezing salaries and benefits for those employees just to effectively pay for those additional costs to employers? Or will it be the case that we will notice that prices start increasing and that it will all be passed to consumers to assist with the company finding those additional costs? So if we just go on to the next slide. So as well as sort of the day-to-day increases in relation to the employer's national insurance contributions and the national minimum wage, there have been increases in regards to employment tribunal awards. So if an employee brings a claim for unfair dismissal, that's been increased from 115,000 to 118,000. Obviously, as I said before, any claim for discrimination is uncapped. There's also other claims where they are uncapped as well. There's statutory redundancy pay. It's being increased to a maximum of 21,570. And the weekly cap has been increased as well. So it's just important when you're looking at any restructures and looking at any redundancy situations that you need to take into account the increased amounts. Also statutory sick pay and the statutory maternity, paternity, adoption pay has all been increased as they are in April every year. So we're now going to pass back to Justin just to look at the case law.
Thank you, Nicola. So we did have a few little cases that we were going to talk about today, and then last week a rather large case came along, and we thought that really no update would be complete without referring to it. And I'm sure everyone is aware, because it's been headline news now for quite a long time, of the, I call it the Scottish case, technically Women of Scotland versus the Scottish ministers. And this is clearly a very sensitive and contentious area. So much so that I'm going to tread carefully and deal with this as an objective lawyer, as you would all expect me to. But the reason this all came about as an issue is around the terms woman and sex. And there was a potential, well, the question was there a conflict between the rules around gender recognition certificates, recognizing gender as female for all purposes? That's what the Gender Recognition Act 2004 says. Was there a conflict between that and the Equality Act 2010 that refers to women, and sex? And the judges decided unanimously that the terms woman and sex refer to a biological woman and a biological sex in accordance with the Equality Act. The judges were very keen to downplay the judgment and point out that it was not a victory for one group or another, because clearly the transgender community and the Women for Scotland community were, very much at odds, and it was a highly charged situation. I think there's no doubt about that. The judges were keen to say, look, transgender people are protected. There is gender reassignment protection under the Equality Act. So there is protection. It is not as if there is a group that is left without protection, but their reading, their interpretation of the Equality Act was that women and sex referred to biological women and sex. It was the Supreme Court. It was the highest court in the land. To some extent, legally, you therefore feel this is the end of the matter, but clearly it's not going to be. I imagine it will be a discussion that carries on for quite some time. As a lawyer, the clarity that this case has provided is welcome. And I don't comment about which way it went. As lawyers, we need clarity, because we can't advise on risk if we don't have clarity. And at the end of the day, that's what lawyers do. They're kind of risk assessors. They look at the risk, and this is why case law is so fundamentally important, because the legislation can't cover every single if and but. And that's why we need the judges to show us the way, so that we can help our clients and show them the way that the law allows. So that clarity is welcome. It will have an impact in the employment sphere. It's a bit too early to go into massive detail, but there is the Commission for Equality and Human Rights is looking at their guidance. It will clearly have an effect on single-sex spaces, and also genuine occupational requirements for a role to be done by a person of a particular sex. It's a very niche point. It comes up very, very rarely, but there will be changes to policies and guidance from employers around that. But I think in more general terms, clearly this is still a very much a public debate, and we will see where this ends up. I mean, one possibility would be for the government to change the legislation, because all the judges have done is interpret the current legislation. But as I'm sure you've all realised, I think all political parties are feeling that this is slightly dangerous territory for them to say too much about it at the moment. So we will see where that one goes. But for the time being, the Supreme Court has made a unanimous judgment around what a woman and what sex means under the Equality Act for sex discrimination, and around what gender reassignment means for transgender people to be protected. But as I say, I think I would be very naive if I said the Supreme Court has spoken and that is the end of the matter. But we shall see. So as I say, there were a few other little cases that we were going to talk about, but as you can see, we've run pretty much to time. So there was nothing seismic. Some years you get lots of case law, which really has a massive impact. This year, not quite so much. What will happen is the Employment Rights Bill will come out, and then there'll be loads and loads of case law, because as I say, the Employment Rights Bill will not cover every scenario. I mean, it can't cover every scenario. So then we will have 2 or 3 years of huge amounts of case law, filling a lot more than an hour of time. But by the end of the 14 years of the Conservative rule, all the new legislation had come out. They've had 14 years, so there wasn't a lot of massive change. There wasn't a lot of massive case law. So that's all we had to say. We have got a couple of questions. What would be the so Selvem has asked what would be the position of a transgender individuals in the Equality Act. And I think I answered that. There is protection within the Equality Act. If you have a sort of specific, I'm very happy if you have a specific question around it, whether it's a policy or whether it's an issue you have, then feel free. There's by magic, there's my number. Feel free to pick up the phone and we can talk it through someone. But I think the judges were very keen to point out that this was, there are other parts, there are other protections within the Equality Act, and that's why they came to the conclusion that woman and sex meant biological woman and sex. I mean, it's an interesting question. If there weren't the protections in the Equality Act, would they have come to a different decision? I'm not even going to speculate on that one.
Thank you very much, Justin, and thank you very much, Nicola, to a lot of information that you were able to impart today, a lot of incredible insights. So thank you very much for that. To our audience, Justin and Nicola's contact information is there on the screen in front of you. We do encourage you to get in touch if you have a question, a comment, if there's anything that you want to speak about. Justin, Nicola, I wonder if just in the final 2 minutes, if there's any closing comments, or if there's anything that you would like our audience to leave today's session with, any sort of knowledge or information that you'd like to impart before we close today.
Well, I mean, for my part, I think I would encourage people, I think I've already said it, but to get involved in the consultation if they feel so inclined, if they feel strongly about the Employment Rights Bill stuff that's coming down the line, get involved in it. But also don't let it take you by surprise when it comes out. So I've hopefully given lots of tips. I did try and focus on that, on what you should be doing now. I don't have all the answers. I'm not pretending I have, because the legislation hasn't come out. But we've got enough feelers now to know what you should be looking at. And hopefully I kind of really flag those. So have a look at that. And if you need any further guidance on any of that, yeah, please just give us a call. We can talk you through it. But be prepared, as any ex-Boy Scout would say. Be prepared. Don't let this take you by surprise. I think that's what I would say about the bits I spoke about.
Yeah, I think for me as well, with the sort of sexual harassment, it's really important to make sure that you've got your policies in place. You're doing those risk assessments as and when necessary, and just with things generally, just making sure that you're training managers to be able to speak to people sympathetically, dealing with any support that they may need, and just trying to generally look after your employees and take any complaints seriously.
Brilliant. Thank you very much, Justin, Nicola. It's been a pleasure to spend an hour today with you. I hope to see you again soon. And to our audience, thank you very much for being with us. I hope you have a lovely rest of your day, everyone. Goodbye.
Thank you very much.